Ladies and gentlemen, our opening ceremony is about to begin. Please stay inside the Zoom meeting and make sure to turn on your camera. Bismillahirrahmanirrahim.
Assalamualaikum warahmatullahi wabarakatuh. Peace be upon you.
Alhamdulillahirabbil alamin wa bihi nasta'in wa ala umuri dunya waddin wassalatu wassalamu ala asrafil anbiya'i wal mursalin wa ala alihi wa sahbihi ajmain amma ba'du.
Good morning, ladies and gentlemen. Today, on the 21st of March 2024, marks the fourth day of the Faculty of Law and Master of Notary program of Yarsi University's International Short Course 2024, entitled The Dynamic of Indonesia Legal System, Challenges and Opportunities in 5.0 Society, with the two main focus of discussions being opportunities and challenges, legal aspect of intellectual property in 5.0 era, and
Contract Law in 5.0 Society, Challenges and Opportunities.
This event was organized to help participants who are interested in law to seek the opportunities and challenges in the 5.0 society within the legal aspect, the urgency of legal reform, contract law in 5.0 society, and arbitration in dealing with 5.0 society. First of all, let's express our gratitude to Allah subhanahu wa ta'ala for the endless blessings which allow us to participate at today's event in a great condition. We also convey our sincere prayers and greetings to Prophet Muhammad sallallahu alaihi wasallam, whose intercession we await in Yawmul Qiyamah later.
Amin ya Rabbal Alamin. Before we start, we would like to mention some of our most honorable guests. The founder of Yarsi Foundation, Professor Dr. Jurnalis Udin, PAK. The chairwoman of Yarsi Foundation, Professor Dr. Santi Jurnalis, SPA, MKes. Director of Yarsi University, Professor Dr. Fasli Jalal, PhD. The Dean of the Faculty of Law, Yarsi University, Dr. Haj Muhammad Rian Bakri, SHMH.
The Director of Yarsi University Postgraduate Program, Professor Dr. Chandra Yoga Aditama, SPPK, DTMNH, MARS, DTCE, FISR. Deputy Dean 1 of the Faculty of Law, Dr. Liza Evita Jakfar, SHMHum. The Head of Master of Notary Program, Dr. Chandra Yusuf, SHLLM, MBA, MMGT. And all of the participants who still have the spirit to catch up with our exciting agenda for today.
Before we move further into our event, let us introduce ourselves as the Master of Ceremony in today's event. My name is Muhammad Dafa Bayanaka, and here is my partner,
Aldafi Irfan Abrar.
We will guide you from the beginning until the very end of today's event.
Ladies and gentlemen, in this morning, we have several agendas to follow. The first one being the opening of Yarsi International Short Course Program 2024. Second, reading of the moderator's resume. Third, the presentation of our first topic, opportunities and challenges, legal aspect of international property in 5.0 era, which will be presented by our great speaker, Professor Dr. Haj Endang Purwaningsi, SHMHum MKN. Fourth, the discussion session. Fifth, our photo/documentation session. And then last but not least, for the morning session, this is something new, Dafa?
What is it?
We will have a 1-hour break to end off our morning session.
After that, we will continue with the presentation of our second topic, Contract Law in 5.0 Society, Challenges and Opportunities, which will be presented by another of our wonderful speaker, Attorney Jodel Labordo. Then, we will have a 30 minutes discussion session. Lastly, the photo/documentation session.
All right, everyone. Before we start our first discussion for today, let's check out our moderator's resume first. Mr. Kuku Fadi Prasetyo, SHSEMH. He has 2 bachelor degrees, one being law and the other being economics, both at the University of Jember. On top of that, he also has a master degree in law at the University of Indonesia. His teaching focus and research interests are on state administrative law, labor law, and the philosophy of law.
Without further ado, let's dive into our first discussion session with the topic, Opportunities and Challenges, legal aspect of intellectual property in 5.0 era, which will be led by Mr. Kuku Fadli Prasetyo, SHSEMH. To Mr. Prasetyo, the stage is yours.
Assalamualaikum warahmatullahi wabarakatuh. Is my voice clear? Assalamualaikum warahmatullahi wabarakatuh. Will everyone hear my voices?
Waalaikumsalam warahmatullahi wabarakatuh. It is clear, sir.
Okay. Okay, I'm sorry for coming late. Today, for today's session, I'm again assigned as a moderator. For this Thursday morning session, I would like to re-announce our first rule. The first is while the speaker delivers the presentation, the participants is not allowed to set his or her microphone on. And then after a 1 hour presentation, all participant can ask the presenter, the speaker to answer about the question. And then the third rule is by clicking raise hand toggle on your Zoom screen, you will be in queue for Q&A session. And the last one, once the moderator allowed you to get involved in a discussion, you can set your microphone on and raise your question. Okay. First of all, let me introduce our Thursday morning speaker. She is Professor Endang Purwaningsih. She is a full-time lecturer at Yarsi Law School, and I would like to have a help from technical team. Technical team, would you like to can you share the Prof Endang curriculum vitae? Okay. Profesor Dr. Hajah Endang Purwaningsih SH MHum is a full-time lecturer at Yarsi Law School. She wrote a number of books and journal articles relating to the topic of intellectual property rights. And then she is also well-known lecturer with high performance in community service activities. And then it will be better for us to have a good profile of Prof. Endang by watching a short video short video will be played for a minute, I think. And then yeah, technical team, can you start the video?
Assalamualaikum.
Yeah.
I'm Endang Purwaningsi, usually addressed Prof. Endang in Yarsi campus. Let me share with you a brief overview of my daily activities as a lecturer. I actively carry out the higher education Tridharma at Yarsi University, Jakarta. Higher education Tridharma refers to the three obligations for lecturers in education, research, and community service. Originally, I come from Java, specifically Central Java. It is in the central of Java Island. Then I moved to Jakarta when I got a position in Yarsi University 20 years ago. I know well all the intellectual property rights in Java. Have you ever heard of gudeg or herbal medicine? Yes, that's the pride of Javanese and some Indonesians. Perhaps you've also tried rendang? It is also one of the Indonesian culinary pride. There are many others, of course. My daily activities as a lecturer are teaching, for sure, both from the law undergraduate program and Master of Notary program. I occasionally take part in activities at other campuses. My scientific focus is IPR, which includes research and community service. Mostly, I carry out activities that relate to empowering communities who need assistance in obtaining IPR. I've conducted many research in many regions in Indonesia. I've worked with many stakeholders during the research, and all the community members whom I work with are very friendly. They are willing to work together well. I have worked hand in hand for many years in fulfilling legal entities and legal products, such as establishing legal entity association, establishing cooperatives, facilitating halal and trademark, also computer program facilitation. Maybe you know the very charming areas in Indonesia, such as Bali, Raja Ampat, or Toba. However, you need to visit more areas in Indonesia, such as Aceh, Madura, Banten, Yogyakarta, Toraja, and others. There are many extraordinary local uniqueness that you can find there. The indigenous people in the areas are very friendly. You will experience genuine hospitality of the people, meet supportive local governments, and participative micro, small, medium enterprises actors. Furthermore, we embed IPR material in our independent learning curriculum to support successful learning. As we know, the IPR legal system in Indonesia is regulated accordingly in three related aspects of intellectual property rights, which is based on the results of WTO. The existing policy conditions are also very supportive, including during the pandemic. IPR is beneficial for the growth of science and technology, for increasing all elements of society awareness, including business actors, precisely micro, small, medium enterprises. Likewise, the Indonesian government's policy keeps on encouraging industries to produce more creative and innovative products to create competitiveness with other similar products and establish a conducive climate and healthy business competition. Hopefully, Indonesian IPR is more appreciated globally. Amin. Thank you. Assalamualaikum.
Waalaikumsalam warahmatullahi wabarakatuh. Okay, now I would like to invite Professor Endang Purwaningsih to join us. Professor Endang, how are you today, Prof? How are you today, Prof? Prof Endang, I cannot hear your voice, Prof Endang.
Good morning. Assalamualaikum.
Waalaikumsalam warahmatullahi wabarakatuh. Okay. Ready to start your presentation, Prof. Endang?
Yes, that's right.
Okay. Okay, Prof. Endang, the time is yours. Please.
Okay, thank you for Mr. Kuku, my moderator today. Assalamualaikum, good morning everyone. I'll
Good
talk
morning.
about opportunities and challenges of implementing artificial intelligence to achieve intellectual property law in the Society 5.0 era. What I'm going to highlight in this presentation, as you can see from the title, is the opportunities and the challenges legal aspect of intellectual property in 5.0, to be specific, Indonesia's intellectual property rights. The purpose of this presentation is to share with you an impact of implementing EA to achieve IP law in the Society 5.0 era in Indonesia. First, I will talk about the underlying factors why this issue is crucial. It is important to discuss the legal aspects of implementing EA in the era of 5.0 because legal frameworks are necessary to regulate the use of EA systems, ensure compliance with ethical standards, and protect the rights of individuals. EA
Prof.
technologies.
Prof.
Yes.
Your presentation? Oh, okay. It has already shared on screen. Okay. Yeah, you may continue your presentation, Prof. I'm sorry.
EA technologies often involve intellectual property issues related to patents, copyrights, and trade secrets. Legal frameworks can help protect the intellectual property of EA creatures and promote innovation while preventing the misuse or unauthorized use of EA algorithm and data. Then we need international cooperation because of EA transcends national borders, making international cooperation essential for developing consistent legal standards and regulation. Harmonizing legal frameworks across different jurisdictions can facilitate the responsible and ethical deployment of EA technologies globally. In my opinion, addressing the legal aspects of EA implementation in the era of 5.0 is crucial for fostering innovation, protecting individual rights, ensuring accountability, and promoting ethical EA development and deployment. Also, we will discuss the opportunities and challenges of implementing artificial intelligence to achieve intellectual property law in the Society 5.0 era. Opportunities refer to the potential benefits or positive outcomes that can be gained from the application of EA in the context of intellectual property law. Meanwhile, challenges refer to the obstacles or issues that may arise during the implementation of EA in this regard. The topic will explore how the implementation of EA can bring significant benefits in improving the intellectual property legal system, such as increasing the efficiency of the patent registration process or facilitating the management and protection of copyrights. However, we will also discuss various challenges that need to be addressed, such as privacy and data security issues, differences in legal interpretation by EA systems, or even the risk of replacing human jobs with technology. So the essence is to explore how EA can be effectively implemented to achieve the goals of intellectual property law in the Society 5.0 era, while identifying and addressing the challenges that may arise during the process. Second, about problems of IPR, substance, subject, object, and infringement of IPR. Let's learn together an introduction to what intellectual property rights are. Basically, IPR arises from ideas and human creations that are realized, protected by law as exclusive rights, both for the reproducing and licensing for commercialization. This IPR is divided into two major ones, which we know as industrial property rights and copyrights. Don't forget that IPR contains moral rights, and economic rights. Economic rights are the right to obtain economic benefits, and moral rights are the right to keep the name of the creator or inventor on his creation or invention. For example, if you sing a song at a commercial event, you cannot claim the song as your creation, but state the name of the creator clearly. This leads me to my next point, sorting out IPR. That industrial property rights include trademarks, patents, designs, trade secrets, integrated circuits, and others. And on the other hand, copyrights includes copyrights and related rights, as in just on slides 3 and 4. On slide 4, we can see that industrial property rights cover all creation in the fields of patents, trademark, including geographical indication, trade secrets, industrial designs, and plant variety breeding. While copyrights cover protection in the fields of artistic creations, science, and related rights such as actors, sounds, recording producers, and broadcasting institutions. So the scope of IPR protection covers science, art, and technology, and the forms protected are, of course, realized ideas, technological information, and their results, which essentially have commercial value. If it has no commercial value, people will ask why it is protected. Please move the slide to slide 6. In one good or trade product, for example, a cell phone, there are many IPRs, such as trademark, patents, and copyrights, as well as integrated circuits. I'm sure that ladies and gentlemen are able to say, for example, what you are wearing today actually contains any IPR. I often give keywords to my students. When talking about patents, you must be talking about technology. When talking about copyrights, you must remember automatic protection. And when talking about trademarks, you must remember the differentiating power of goods. Then next slide 7. So we understand that one product can contain many IPR, and it needs to be agreed that ideas are protected as long as they have been realized and published. But then the question rises, what are the legal consequences of publication on copyrights? And how is it different from the legal consequences of publication on patents? Because it might reduce novelty as one of the requirements for obtaining a patent. Then as on slide 8, in Indonesia, it is known as traditional knowledge, which can also take the form of folklore. There are many people's products that have been passed down from generation to generation of the Indonesian people, and some of them have been protected with geographical indications, even recognized by UNESCO. As you can see, the rule of law in this issue has been available. It is the law number 20 of 2016 on the trademark and geographical indication. It mainly stipulates that branding effort can be applied and obtained either individually or collectively. If you have ever visited many areas in Indonesia, of course, you know about traditional herbs, jamu, wedang uwuh, rendang, ubi cilembu, gudeg, and others that are challenging to trade. The local government and related institutions, especially in the Ministry of Cooperatives and Small Medium Enterprises, has been struggling to maximize the potentials of human-scaled producer of traditional food or herb so that they are able to be more competitive. And next slide, please. The background of the existence of the IP protection. We
We know that the presence of IPR in Indonesia coincides with the arrival of foreign investment under the pretext of technology transfer. We also understand that our nation's communal culture is very friendly and open information. For example, about the contents of medicinal plants will be provided as widely as possible to those who ask. Likewise, with the ratification of trade-related aspect of intellectual property rights as compensation for members of the WTO, we inevitably have to comply with the commitment to full compliance to accept and prepare a conducive climate and appropriate regulation for IPR. In this way, it is hoped that IPR will also build Indonesia's technological and economic growth, as well as stimulate the rise of innovation and new IPRs from Indonesia itself. Indonesia concerns to stimulate the growth of domestic technology and industry, fostering an innovative spirit, developing indigenous technological capabilities, increasing a culture of IPR, protecting traditional knowledge, including folklore, protecting the creation of the nation treasure, and preparing regulation for the implementation of EA. Let's take a moment to look at the basic principles of IPR for each item, but I will only explain them in general and focus on several items, namely copyrights, patents, trade secrets, trademark, and industrial designs. We know Indonesia has already many regulations in the field of IPR. Copyright is regulated by Law Number 28 of 2014. Patent rights is regulated by Law Number 13 of 2016. Trademark rights is regulated by Law Number 20 of 2016. Trademarks and geographical indication, and Law Number 31 of 20 regarding industrial designs. Let's continue to copyrights. Copyright is the exclusive right for the creator or recipient in the right to publish or reproduce their work or give permission to do so without reducing restriction according to the applicable laws and regulation. Generally, the object of copyrights are art, literature, and science. Creation means the authentic work of a creator, and in science, art or literature. The term of copyright protection is basically the life of the creature plus 70 years. A person or several people together whose inspiration gives birth to a creation based on the ability of mind, imagination, dexterity, skill, or expertise, which is expressed in a unique and personal form. Then copyright law protected creation covering books, computer programs, pamphlets, layouts of published written works, and all other written works, lectures, speeches, and other similar creation. Teaching aids made for educational and scientific purposes, songs or music with or without text, drama or musical drama, dance, choreography, puppetry, and pantomime, fine arts in all forms, such as painting, drawing, carving, calligraphy, sculpture, college, and applied arts, architecture, map, batik art, photography, cinematography, translation, tafsir or interpretation, adaptation, anthologies, databases, and other works resulting from translation. Then we continue to related rights. You just imagine if there is a singer who able to present a performance that's different or better than previous singers or their creatures, perhaps even increasing their popularity. With a different style, perhaps with melodious sound, makes the song more interesting and beautiful. That's performing rights. the exclusive right for the performers to reproduce or broadcast their performance. The producer of the sound recording has the right to reproduce or rent voice recordings or sound recordings. Broadcast institutions also have the right to create, reproduce, or broadcast their broadcast works. These rights are protected by law to ensure fair compensation for the creative works of performers and producers. Please slide 19. The characteristic of copyrights. Creation are protected by law as long as they have been published. The requirements for publication are originality and individuality. The term automatic protection in copyrights refers the fact that when a creative work is created and expressed in a recognizable form, such as writing, music, or image, copyright is automatically granted to the creator. This means that the copyright owner doesn't need to register or take any other steps to obtain legal protection for their work. However, it's important to remember that this automatic protection state serves as initial evidence, or we call it prima facie evidence of copyright ownership. This implies that in the event of legal disputes or copyright infringement, the copyright owner must be able to prove ownership and authenticity of their work in court or other legal forums. Although there is no requirements for copyright registration to obtain copyright, registration can assist the copyright owner in proving ownership more easily in court. So in Indonesia, copyright protection and law enforcement are carried out well in accordance with the object, namely protecting work of art, literature, and science. We lecturers also have many copyrights on books, research results, such as computer programs, and work of art, such as recordings of learning activities or community service activities. Both moral rights and economic rights are respected and appreciated for their implementation, but consistent law enforcement is still needed so that there is no piracy of creation. Perhaps like in other developing countries, serious attention is needed on this issue. Likewise, in the commercialization of copyrights, there are 3 pillars that need to be synergized, namely regulation, management, and law enforcement. Conducive and firm regulation are needed on the commercialization of copyrights. Simultaneously, the government's role in increasing public legal awareness. Now we go to patent, slide 23. Patent is exclusive rights granted by the state to inventors for the results of invention in the field of technology for a certain time, or to give approval to other people, etc. Patents are protected for 20 years and simple patents for 10 years. And we know Indonesia have patentability requirements. Novelty. A claim lacks novelty if every element or step is explicitly or inherently disclosed within the prior art. The fundamental question is novelty. Whether someone else has already invented the thing you are trying to patent and has either patented it, sold it, offered it to the public, or described it in a printed publication. If they have, then you do not get the patent. Then inventive step. Inventive step is generally assessed by asking, given the known prior art, would the claimed invention be of use to a person skilled in the art? The person skilled in the art, also known as the skilled person, is a fictional character in the relevant field of the technology who is good at their job but has no inventive. The condition of inventive step, or we call it non-obviousness, is fulfilled if the invention as a whole, compared to the prior art as a whole, would not have been obvious to a person skilled in the art. Then, industrial applicable. An invention shall be considered as susceptible of industrial application if it can be made or used in any kind of industry, including agriculture. The interpretation of the word industry is to be understood in the broadest possible sense. Basically, the difference between a patent and simple patent lies in the number of claims, the period of protection, and the conditions required. In slide table 25, it can be seen that for a simple patent, there is only one claim, and the protection is only 10 years and does not require fulfillment of the inventive step requirements. Meanwhile, a patent can have more than one claim. The protection is 20 years and all conditions must be met, including novelty, inventive step, and industrial applicability. Then the registration of the invention to obtain a patent is carried out using a first to file system. Whoever registers first has the opportunity to become an inventor. The filing date is used as the basis for the calculation, namely the date the registration was received without further correction. We must pay attention to how the claims in the patent area patent are made. This claim reflects the essence of the invention for which patent protection will be requested. So it should not be too broad or too narrow. Keep in mind the scope of monopoly patents rights that will be obtained. Consider the breadth of technological and economic aspects that will be covered later due to making inappropriate claims, possibly giving rise to many competitors or even infringing registered patents previous. Let's go to next slide about trade secret. Maybe our grandmother or mother made traditional herbs from the formula or which no one knows, and we don't want the secret of the herbs to be shared with the public. Then we can continue to keep it in a secret forever, even to our great-grandchildren. There are also manufacturers who feel they will be luckier if their technology is not patented, but is enough to become a trade secret. The reasons are, of course, many. Apart from the limited protection period if patented, trade secrets can also be passed down from generation to generation indefinitely as long as no one leaks them. Maybe you have certain special ingredients such as anti-aging or anti-poverty or anti-poor. Just kidding. Then trade secrets are information that is not known to the public in the field of technology on business, has economic value because it is useful in business activities. The scopes of trade secrets are production methods, processing methods, sales methods, or other information in the field of technology and or business that has economic value and is not known to the general public. To obtain trade secret rights protection, you do not need to register in the Directorate General Intellectual Property Rights. According to Article 3 of the Trade Secrets Law, trade secrets acquire protection if confidential, if the information is only known by certain parties or is not generally known by the public. Then has economic value if the confidential characteristic of the information can be used to carry out commercial activities or businesses or could increase economic profits. Then, confidentiality is maintained if the owner of the parties controlling it have taken appropriate and proper steps. Need to be considered when protecting trade secrets are when someone creating or discovering new invention in the form of information with economic value deliberately kept as confidential information and deliberately retained as confidential information. The owner is obliged to maintain the confidentiality of his product, and if it is licensed, then it needs to be listed. In fact, the most important thing is that an agreement needs to be made both between trusted employees and any staff related to distribution and processing, not only when they are employees, but at any time they must not violate agreements regarding company secrets or products or formulas. So you need to make a confidential agreement. Let's move to trademark, slide 35. As mentioned at the beginning, talking about trademarks is talking about signs or differentiating products. Trademarks can be created with names, words, letters, numbers, colors, and combination thereof, and these marks are valid for 10 years. Then they can be extended more. If you have any product, branding your product with trademarks, service marks, and collective marks. Maybe you know well-known marks, many of which are world famous, such as Honda, Toyota, and others. Trademark is special characterized like your ID card to differentiate production results produced by a person or several persons jointly or by a legal entity from those produced by another person or by another legal entity. Also, as promotional or advertising tools to promote their production simply by mentioning the trademarks, guarantee of quality goods or services products, also as instruction for the origin of goods or services produced and tools to build the company's reputation. For a moment, let's give empathy to our micro, small, medium enterprises actors so that we are also aware of them. They are still largely traditional in both production and commercialization. Despite the huge industrial potential of Indonesian traditional wheat shared by thousands of traditional producers, these people like micro, small enterprise, sadly to say, still have poor mindset. They just produce what they can produce the way they can produce without considering competitive factors. In many cases, they fail to penetrate wider markets. It is completely understandable since these traditional producers do not pay attention to, for example, hygiene standard, catchy packaging, and more importantly, registered mark. For them, what they can produce is more than what they can expect. They are really grateful for being able to earn a living from what they can sell. They are not willing to go beyond. They are simply not interested in the extra mile. This poor mindset, which lacks competitive spirit and legal awareness, results in poor competitiveness. So, in spite of the measures by the government, these traditional producers seem to be going nowhere. Let's make them aware and let's collaborate with stakeholders such as the government and related agencies to accompany and facilitate more of our micro, small, medium enterprises trademarks, especially those on a micro scale. We, as academia, the roles of academia, assisting socialization of legal entity, intellectual property rights, especially enhancement of understanding of trademark and geographical indication. So the importance of trademark registration is to get legal protection, exclusive right to use the trademark, opportunity to license or sell, increasing power in negotiation, provide a positive image for the company, and increasing market share. We continue that to create a brand, you must pay attention that it must not violate laws and regulation, public order, and religious, moral, and decency. Trademarks must also not be created in bad faith. We call it iktikat baik. For example, to resemble well-known or registered marks, so then get infringement because of similarities in essence or as a whole. If you have a coffee product, don't make it a coffee brand. Make a brand with words that are unique, easy to memorize, have a strong character, but don't infringe anyone's trademark. Then next to industrial design, slide 47. Industrial design is creation protected by the Design Act, can be in the shape of 2 or 3 dimensions. Requirements of industrial design are aesthetic, new or novelty, and tangible. Aesthetic effects, of course, is subjective assessment. Design law gives a monopoly right to the owner of a registered design with the fulfillment of the aesthetic, not functional requirement. New or novelty means on the date of acceptance, the industrial design is not the same as the previously existing disclosure. Tangible means the product is visible, can be seen or real. Now we go to slide regarding EA and its impact. EA, we call it artificial intelligence, is a technology designed to create computer system, notably artificial intelligence algorithms are used for data processing, calculation, testing, and automatic problem solving, capable of mimicking human intellectual abilities. EA enables computers to learn from experiences, identify patterns, make decisions, and complete complex tasks quickly and efficiently. Please direct to slide 56. Legal aspects of artificial intelligence implementation in the Society 5.0 era. Society 5.0 is a concept proposed by the Japanese government as the embodiment of the evolution of society that combines information and communication technology with everyday life to create a society focused on human welfare. This concept presents a vision of the future where technologies such as EA, Internet of Things, big data, and robotics are widely used to enhance human quality of life, address social issues, and achieve sustainable development. We have some key features of Society 5.0 are technology integration. Society 5.0 proposes the integration of advanced technology into all aspects of daily life, including industry, education, healthcare, transportation, and more. And then balance between technology and humanity. Despite focusing on technology, Society 5.0 also emphasizes the importance of balancing technological advancement with human interests. Technology is expected to enhance human quality of life and well-being rather than completely replace human rules. And then resolution of social issues. The concept aims to solve existing social issues such as environmental problems, healthcare, transportation, and demographics using technology as a tool to achieve more effective solutions. Then inclusivity and community engagement. Society 5.0 emphasizes the importance of inclusivity and community engagement in the development and implementation of technology. Active participation from various stakeholders is expected to ensure that technological developments address the needs and interests of all members of society. And then finally, sustainability. This concept emphasizes the importance of sustainable development, both environmentally and socio-economically. The use of technology is expected to help create environmentally friendly solutions and address social inequalities. Society 5.0 is not just a concept, but also part in the Japanese government's development strategy to achieve sustainable economic growth and improve the overall quality of life for citizens. EA-based technology has begun to be applied in the public sector in Indonesia, especially in increasing the speed and quality of public service through a citizen-centric approach. The implementation of artificial intelligence technology takes into account the values of artificial intelligence ethics, including inclusivity. The implementation of EA needs to pay attention to the values of equality, justice, and peace in producing information and innovation for the common good. And then humanity, the implementation of EA needs to pay attention to human values by continuing to protect human rights, social relation, beliefs held, and everyone's opinions or thoughts. And then security. The implementation of EA needs to pay attention to the security aspects of users and the data used in order to maintain privacy and personal data and prioritize the rights of electronic system users so that no party is harmed. Accessibility. The implementation of EA is inclusive and non-discriminatory. Every user has the same rights in accessing the administration EA-based technology for its benefit while maintaining the applicable EA ethical principles. And then transparency. The implementation of EA needs to be based on transparency of the data used to avoid misuse of data in developing technological innovation. And then credibility and accountability. The implementation of EA needs to prioritize the ability to make decisions from the information or innovation produced. Information generated through EA must be trustworthy and accountable when distributed to the public. Protection of personal data. Implementation of EA must ensure the protection of personal data in accordance with statutory provisions. Sustainability development and environment. The implementation of EA considers the impact it has on humans, the environment, and other living creatures to achieve sustainability and social welfare. Finally, intellectual property. The implementation of EA is subject to the principle of protecting intellectual property rights in accordance with statutory provision. Then the opportunities of EA implementation are legal accountability. When EA is used in critical decision making, such as in judicial system, such as in healthcare or security, questions about who is responsible for the consequences of this decision become highly relevant. Clear and transparent legal protection are needed to determine response at is also necessary in an era where EA is increasingly connected to complex networks. Protection against cyber attacks becomes urgent. The law must provide an adequate framework to protect EA systems from security threats and outline legal responsibilities in the event of security breaches. The challenges are privacy and data protection, legal responsibility, bias and discrimination, cybersecurity, transparency and accountability, international regulations, also ethics and societal values. We learned a lot of theories such as stakeholders theory, agreement theory, responsive law, and others. The point is, in implementing EA, we must pay attention to the ethics and regulation of its use and position humans as the subject of responsibility and centrality. The theory of responsiveness to EA refers to the idea that as EA systems become more prevalent in society, there should be corresponding frameworks, regulation, and ethical consideration in place to ensure that EA technologies are developed, deployed, and used in a responsible and accountable manner. The key points regarding the theory of responsiveness to EA, ethical frameworks. As EA technology evolves, there is a growing recognition of the need for ethical guidelines and principles to govern its development and use. These frameworks may address issues such as fairness, accountability, transparency, privacy, and bias mitigation in EA system. And then regulatory oversight. Governments and regulatory bodies are increasingly called upon to establish regulation and standards for EA technologies. This regulation may cover areas such as data protection, algorithmic, transparency, safety standards, and liability for EA-related harms. And then public engagement, it is essential to involve the public in discussion about EA technology and its societal implication. This includes raising awareness about EA, soliciting feedback from diverse stakeholders, and fostering public dialogue about the ethical, social, and economic impact of EA. And then human-centric design. The theory of responsiveness to EA emphasizes the importance of designing EA system with human values and interests in mind. This includes prioritizing safety, usability, and the protection of human rights in a development processes. And then continuous monitoring and evaluation. As EA technologies are deployed in various contexts, there is a need for ongoing monitoring and evaluation to assess their impact on society. This may involve collecting data on EA performance, measuring outcomes, identifying potential risk or bias, and making adjustment as needed. Overall, the theory of responsiveness to EA underscores the importance of proactively addressing the ethical, legal, and societal implication of EA technology to ensure that it benefits humanity while minimizing potential risks and harms. Sorry. Please go to slide 59. Legal aspects implementation of EA in the Society 5.0 era in intellectual property law. Okay, thanks. We must pay attention to copyright management, utilizing machine learning technology to identify copyright infringement in digital content, including music, videos, and text, using artificial intelligence systems to monitor and assess the originality of artworks or digital products to support the copyright granting process. And then there is plagiarism detection. implementing natural language processing algorithm and machine learning to detect and prevent plagiarism in research, publication, or other digital content. And then trademark and patent management, using data analysis and EA to monitor trademark online and detect potential trademark or patent infringements. Utilizing technology to support the patent application and management process more efficiently. Also, we pay attention to digital law enforcement, using EA to support investigation and enforcement related to intellectual property rights infringement, including monitoring online transactions and disclosing infringements. Then legal risk analysis, applying EA-based data analysis to evaluate legal risks related to intellectual property rights infringements and provide strategic advice to companies or individuals. And then there is automated licensing, utilizing blockchain technology and smart contract to automate licensing processes and intellectual property rights management, allowing industry players to share and use rights more easily and legally. Then intellectual property portfolio management, implementing EA-based management system to assist companies or individuals in managing their intellectual property portfolios more efficiently, including monitoring and status and expression of rights. Then intellectual property dispute resolution, utilizing EA-based mediation technology to resolve intellectual property disputes more quickly and efficiently, applying applicable legal principles. Intellectual property policy formulation, using predictive analysis to assist governments or policy-making institutions in developing responsive intellectual property regulations to technological advancement. Finally, now we have so many challenges: understanding and legal adaptation, complexity of intellectual property law. Intellectual property law is often complex and constantly evolving. The use of EA in managing aspects such as patents, trademarks, and copyrights requires a deep understanding of regulation and legal change. Legal and ethical adaptation. The development of EA must consider legal and ethical adjustment to comply with intellectual property norms and principles. Then protection of intellectual property rights, data security and privacy. EA often requires access to large data sets to train its models. It is important to ensure data security and privacy, especially when the data used involves intellectual property information. Then prevention of intellectual property infringement. Challenges in developing EA systems can identify and prevent intellectual property infringement. Clarity and legal interpretation. Interpretation of legal text. Although EA can assist in analyzing legal text, accurate and precise legal interpretation often still requires human judgment, especially in the context of intellectual property, which is often highly contextual. Copyright infringement. Machine learning can be used to detect copyright infringement, but challenges may rise in accurately determining whether a use infringement copyrights. International law enforcement. Intellectual property infringement often involve jurisdictional limitations, and international coordination is required for effective law enforcement. Accessibility and equality. Access to artificial intelligence. Not all parties have equal access to artificial intelligence technology. This can create accessibility gaps, especially in countries with limited resources. Equality in intellectual property protection. It is important to ensure that the intellectual property protection provided by EA systems is fair and equal for all stakeholders. And then responsibility and accountability. Legal responsibility. EA can present challenges in establishing legal responsibility in case of errors or violation of rights. Algorithm transparency. The opacity of EA algorithm can be a barrier in determining how decisions affecting intellectual property rights generated. Regarding intellectual property rights, regulation governing intellectual property rights and EA may vary between jurisdictions, and their implementation depends on local and international legal interpretation and policies. Therefore, in the context of EA use, especially concerning IPR, it is crucial to consult legal experts who understand local and international provisions. The implementation of EA in IPR in the era of Society 5.0 can improve efficiency, accuracy, and orderliness in the management and protection of intellectual property rights. However, as with all EA application, ethical consideration and legal compliance remain important to ensure that this technology is used correctly and in line with societal values. So the implementation of EA for any purpose, especially for society, must be based on law and ethics. As community service based on legal protection should be based on optimization of aspiration or rights. Technological approach with compliance to ethical and legal, human-centered society or human-centered control. Also, based on the use of technology towards SDGs, Sustainable Development Goals, that's prioritizing legal protection, synergies of law, technology, society with concerns or humanity. Finally, the relationship between law and the application of EA in the era of 5.0 can be described as confident and evolving. With the advent of EA technologies reaching their pinnacle in the era of 5.0, legal frameworks are challenged to adapt and accommodate the complexities posed by EA-driven systems. One, regulatory frameworks. Legal systems need to develop comprehensive regulatory frameworks to govern the development, deployment, and use of EA technologies. This involves addressing issues such as liability for EA-generated decisions, privacy concerns, data protection, and ethical consideration in EA development. And then two, ethical consideration. As EA systems become more sophisticated and autonomous, ethical consideration become paramount. Legal frameworks must ensure that EA application adhere to ethical standards such as fairness, transparency, accountability, and non-discrimination. And then three, liability and accountability. Determining liability and accountability in cases of EA-generated harm or errors poses a significant challenge. Legal systems need to establish clear guidelines for assigning responsibility when EA system malfunction, make erroneous decisions, or cause harm to individuals or society. And then four, data protection and privacy. EA often relies on vast amounts of data for training and decision-making. Legal frameworks must ensure that data used by EA systems are obtained and processed in compliance with data protection and privacy laws to safeguard individuals' rights and freedoms. And then five, intellectual property rights. The development of EA technologies raises questions about intellectual property rights, particularly regarding ownership of EA-generated content and invention. Legal systems need to address issues related to patenting EA inventions, copyright protection for EA-generated works, and ownership of EA algorithms. 6. International collaboration. Given the global nature of EA development and deployment, international collaboration is essential. Legal frameworks must facilitate cooperation and harmonization of law across jurisdictions to address cross-border challenges related to AI, such as data sharing, interoperability, and standardization. In the era of 5.0, the relationship between law and EA is not just about regulating EA systems, but also about fostering innovation, protecting individual rights, and promoting societal well-being in the increasingly EA-driven world. Therefore, legal frameworks must continuously evolve to keep pace with technological advancement and ensure that EA serves humanity's best interests.
Check.
That's
check.
all I can share. Thank
Check,
you for
check,
your
check,
kind
check.
attention. Assalamualaikum.
Check.
Waalaikumsalam warahmatullahi wabarakatuh. Thank you for your presentation, Prof. Endang. I think it is interesting to have materials that make a contextual bridge between Indonesian IPR law and the technological development in the society 5.0.
Check.
Okay,
Check.
everyone,
Check. Check.
now we come to the
Lagi aman nih.
question and answer
check.
session.
Check,
So
check.
we open
Check.
some opportunities
ini biasanya
for
mati
the
sendiri.
participant to raise a question to the speaker. Okay.
Ini lagi aman.
Okay, Nabila Salim. Okay, Nabila Salim. Okay. Yeah,
Yes.
please.
Okay. My question for professor is, can we as a student allow to use AI in writing our thesis? Doesn't it violate IPR?
Professor, is it clear?
Yeah.
Prof. Endang?
Okay. Thank you for your question. It's
Okay,
really,
you can answer the question, Prof. Endang.
it's really a great question and relevant to the topic. Miss Nabila or Nabila, we say whether the use of EA algorithm data is permissible or not, it's important to respect the author and clearly state the source. This means that if the data source is legitimate and permission has been granted for its use, you should seek and ensure the legitimacy of the source. You must pay attention. It's crucial to properly acknowledge the source of your data. If you're using data obtained from EA or other algorithm, make sure to provide accurate references to the source. This helps maintain academic integrity and prevents copyright infringement. And then ensure that you obtain the data in a legal manner in accordance with the terms of use from the source. Some data source may have license or usage agreements that need to be complied with. And in scriptsy or thesis, you must say true, method, and transparency if you're using EA algorithm to generate or analyze data. It's important to transparently explain the methods used. This helps readers understand how you obtain and process data. And then make sure to evaluate the credibility of the data used. While EA can generate large amounts of data, the quality and reliability need to be verified. Don't assume that all data generated by EA is accurate or relevant. I think it's enough.
Okay, thank you, Prof. Endang. Is there any response, Nabila? Any response? Enough?
I think that is enough. Thank you, Professor, for the answer.
Yeah.
Okay, thank you, Nabila. Okay, we still have a time for participants who are willing to ask a question. Okay, please, you may raise hand and then I will give you an opportunity to raise your question. Okay. No one raises question. Okay. Patricia. Okay, Patricia. Okay, you may ask Prof. Endang, please.
Okay, thank you, Mr. Kuku. Uh, my question is, can AI be called as an inventor in Indonesia? And what legal basis do we rely on to determine this? Is it civil law, intellectual property rights, or Islamic law? Thank you, Professor.
Thank you. Can I answer?
Yeah, you can answer the question,
Yeah,
Prof. Endang.
thank you for Patricia. A great question too. In Indonesia, we know based on civil law, Islamic law, and intellectual property law, we know HKI, yeah? EA is not considered an inventor, as the term inventor or creator typically refers to natural persons or group of individuals. Then the existing legal frameworks governing invention in Indonesia and internationally attribute inventor to human individuals who conceive of the invention. To address the legal status of EA-generated invention in Indonesia, it would likely require amendment to existing intellectual property law or establishing of new regulations specifically addressing this issue. As well as the process would involve consideration of intellectual property in other areas of law, such as civil law, hukum perdata, and if disputes arise concerning ownership of rights over EA-generated invention. While Islamic law provides general ethical guidelines and principles regarding ownership and innovation. Specific legal legal rulings on matters such as intellectual property are typically determined by national legal system. Islamic law would like differ to Indonesian legal frameworks in addressing the legal status of EA-generated invention. I think it's enough. Thank you.
Thank you, Prof. Endang, for the answer. Patricia, any response? Okay, I think it's enough, Prof. Endang. Okay, another participant would like to ask Prof. Endang about IPR, about, about the topics, yeah, about the topics of IPR. Who else? Anyone else? Okay. If there's no one raising question, I think it is the end of the fourth session, yeah, the fourth session in the short course. So I would like to thank to Prof. Endang. Is there any what's that? Is there any last word for the participants, Prof. Endang?
Yes.
Hmm.
I think thank you for your participation and for all lecturers. we must take participation to implement the downstreaming or helirization research results in community service activities because it is important process in transforming the output and outcome of our research, also knowledge from academic level into practical application that can directly benefit to community. Thank you very much. Assalamualaikum.
Waalaikumsalam warahmatullahi wabarakatuh. Thank you so much for Prof. Endang for the final statement. Uh, I think it's time for you to get along with the MC again. So please, MC, Dava and Aldafi, yeah, to come along with us. Okay.
Yes, sir. Thank you very much for
Thank you.
the passing of the agenda. Thank you, Professor Purwaningsi, for sharing your brilliance and sharp knowledge within our first discussion session. And also, not to mention, a huge thank you also to Mr. Kuku Prasetyo for leading our first discussion this morning.
Now, we would like to inform you that we will have a photo session
Please unmute.
to mark the ending of our morning session. Please be advised to turn on your camera.
Technical team. Yeah.
Okay, the first slide, say cheese.
Second slide, let's
Cannot
see
hear
those
anything
beautiful
from the
smiles.
studio. Technical team, could you please? Okay, unmute. Okay. It's already unmuted.
Okay, the third slide, say cheese.
The fourth is your turn.
Okay, next slide. All right, that marks the end of our morning agenda, as we will continue the second discussion later today at 1 p.m. Western Indonesian time. We will leave you to have your well-deserved 1-hour break, and please stay tuned for more knowledge and insight by our exquisite speaker in our afternoon session.
See ya. Good afternoon, everyone, and welcome back to Day 4 of Yarsi International Short Course 2024. After a brief yet needed break, we are finally back to guide you all through the rest of our agenda. All participants, please be advised to turn on your camera and once again, stay inside the Zoom meeting, for our afternoon session is about to commence.
Now, we won't hold you back any longer. Let's go straight into our second discussion for today with the topic Contract Law in 5.0 Society, Challenges and Opportunities, which will be given by our superb speaker, Attorney Judel Labordo, and led once again by our charming moderator, Mr. Kuku Fadli Prasetyo, SHSEMH. To Mr. Prasetyo, the stage is once again yours.
Thank you so much, Aldafi and Dava, our charming master of ceremony for this afternoon. Assalamualaikum warahmatullahi wabarakatuh. Good afternoon, everyone. Again, I'm assigned as the moderator for that for session, yeah, the fifth session here. Okay, before we meet our super speaker, I would like to re-announce the rules as follows. The first rule is that at the time of speaker's presentation, we do warn participants to turn off their microphones. And the second one is after a 1 hour presentation, we will have a question and answer session. And the third is each participant can click raise hand button from their Zoom screen, and then get me notified that you want to ask a question. And then the last rule is that the moderator will allow the participant to raise the question so that you can get contacted to the speaker. Okay. Before we start our fifth session, I would like to introduce our super speaker, Mr. Jodela Bordo. Okay, where's the curriculum vitae? Okay, Mr. Attorney Jodela Labordo, CPA. He is a lawyer as well as a certified public accountant. So he has a double background in accounting and law. And then he has a lot of experiences, I think, from bureaucratic sphere. I think he was a presidential anti-smuggling group. He has a board in presidential anti-smuggling group of the office of President Gloria Macapagal Arroyo. And then he is a law professor of the College of Law of University of Perpetual Help, Las Pinas, Molino, and Binan campuses. And then he is also a law professor at the College of Law in San Sebastian College, Resoletos, Manila. Okay. Okay. Without any speech, I think, yeah, from moderator, I would like to invite Mr. Jodela Bordo to come join with us. Mr. Jodela Bordo.
Yes, good afternoon. Good afternoon, sir.
How are you today?
Good afternoon for that wonderful introduction. Although I am not a superb, I am just also a learner of law, just like you, all of us here. We are a work in process when it comes to knowledge of law. Well, before I formally start with my presentation, with my lecture, I would like to express my deepest appreciation. The pleasure is really mine for having me here in your activity. And I would like to acknowledge the following people, of course, aside from the attendees here, who I believe made this event successful. May I mention the following entities and personalities? We have here, I would like to say thank you also to the University Yarsi, Facultas Hukum. Number 2, we have University Yarsi, Sekolah Paskasarjana. We also have Tutwuri Handayani. We have Campus Merdiko, Indonesia Jaya, and we have the Impact Rankings 2023. And for the individuals who made this possible, I would like to say thank you to my colleague in the University of Perpetual Health. We have our linkages officer in the person of Professor Roderick Ulit of our Calamba campus, and most especially to those officers of Yarsi University College of Law who invited me to share my little knowledge about the topic. We have our professor, Dodik Wijaya, and also our uh, Dean of the College of Law, we have Dr. Muhammad Ryan Bakri. Okay, just please pardon my pronunciation ha, if I was not able to pronounce the words properly because because I am a Filipino. I really am foreign to Indonesian language. Um, how are we going to go about this? Am I going to present my slides, or someone will be presenting it for me? I can present my slides. How will it be?
Yeah, I think your presentation has been already shared in the Zoom screen.
Yes. Can we
Yeah, you
have
can.
it can we have it on the screen?
Yeah, we have already seen your presentation, Mr. Judel.
Okay. So the problem is I I could not see it in my whole screen. Would it be possible if I will be the one to operate so that I could see the whole screen
Okay,
with the slides?
technical
Or
team, technical team, can you stop the presentation share? So Mr. Labordo can share the screen by himself.
yes.
Okay, you can share your screen, I think,
Okay.
Mr.
Anyway,
Labordo.
the slides that I have shared with you
Mm-hmm.
previously is the same exact slides I will be presenting. I just
Yeah,
could not see my slides in the whole screen. Can you see it now?
still in process. Okay, we have already seen your presentation. Yeah, you can start, Mr. Labordo. The stage is yours.
Okay, thank you, sir. So again, ladies and gentlemen, good afternoon. I am here to present a lecture on the dynamic of Indonesian legal system, challenges and opportunities in 5.0 society. In particular, I am going to give a lecture on contract law in society 5.0, challenges and opportunities. Okay, before we go on to the main topic, I would like to give you a brief background of the history of the legal profession. So arguably, the legal profession has its origins in ancient Greece from 12th to the 9th century before Christ, and Rome, the founding of the Italian city of Rome in 8th century before Christ. And during the Middle Ages, after the fall of the Western Roman Empire and the onset of the early Middle Age, the legal profession of Western Europe collapsed. Okay, here comes the first up to the fourth industrial revolutions. And these industrial revolutions happened with the legal profession having intertwined involvement on each of them. And in particular, by the digital information, artificial intelligence, and Internet of Things, or the so-called IoT, being offered by the fourth industrial revolution, Society 4.0, or the so-called information society, is shifting already to the Society 5.0, or 5.0 is already shaping up. Okay, so therefore it can be safely concluded that lawyering has endured and passed the test of time. Now, the question is, ladies and gentlemen, and some here are lawyers and disciples of law, are we supposed to fear Society 5.0? What is Society 5.0? Has it effect on the legal profession? Okay, so these are only few of the many questions that might keep on lingering in our minds. Okay, so with this presentation, are the following subtopics. We have basic concepts on Society 5.0. We have basics in law on contracts in our perspective, the Philippine side. And we also have possible challenges and opportunities and also my references. So we've been mentioning about Society 5.0. And what is Society 5.0? So we need to know the basic concepts again on Society 5.0, that is a human-centered society that balances economic advancement with the resolution of social problems by a system that highly integrates cyberspace and physical space. Okay, this Society 5.0 has been first introduced by Japan in its report on the Fifth Science and Technology Basic Plan by the Council for Science and Technology and Innovation of the Cabinet Office, Government of Japan. And this actually started in December 18 of 2015. So that is sometime 9 years ago already. Okay. And Japan is envisioning that in this society, various social challenges or problems are solved by incorporating the innovations of the fourth industrial revolutions. Okay, so what are the innovations of the fourth industrial revolution? We have the so-called Internet of Things, we have the big data, we have artificial intelligence, we have also this robotics, and we have uh, blockchain. So these are the things that have been developed during the fourth industrial revolutions. Okay. So here, I am presenting to you the 5 societies that humanity underwent from the very beginning, from the start of humanity up to Society 5.0. So we have here Society 1.0, that is hunting and gathering. Next, we have Society 2.0, that is agricultural society. Next, we have industrial society, that is 3.0, and we have information society, that is Society 4.0. And as I have told you, the fruits of the fourth industrial revolution are now being used to create Society 5.0, which was again initiated by Japan. Next presented to you are the timeline of humanity, okay, in relation to the 5 societies. So we have the birth of human beings. That is also the first society in which the main focus is coexistence with nature. So that is hunting society. And we came to 13,000 before Christ. Okay, so this is the second society, and there was development of irrigations. We also have establishments and settlements of agrarian society. And third society happened at the end of the 18th century. Okay, that is the industrial society. There was invention of steam locomotives, start of mass production. Okay, and the fourth society happened in the latter part of the 20th century, where invention of computers, start of information distribution. Okay, and now the fifth society is happening. That is the super smart society. Okay, that is the start of the 21st century. Okay, now if we are going to combine these 5 societies with the 4 industrial revolutions, we could come up with the presentation in the slide. Okay, because there is actually difference in the happening of these 5 societies with the four industrial revolutions. Because of course, the society started when humanity started, whereas industrial revolution just came later. Okay? So we have here, the first industrial revolution actually started during the third society or the society 3.0. Okay? So in society 3.0, it started the first industrial revolution. We also have the second industrial revolution. And also towards the end of society 3.0, it started the third industrial revolution, that is computer internet, okay? Going to society 4.0. And in society 4.0, that happened the third industrial revolution fully and also the start of the fourth industrial revolution. So there has been overlapping of happenings. Okay, on one side, the society, and on the other side, the industrial revolutions. As I have told you, the benefits and the innovations made in the fourth industrial revolution, the so-called Internet of Things, the so-called blockchain, the so-called big data, okay, are being used to come up with Society 5.0. Okay, so as described by the government of Japan, this is how Society 5.0 look like. So it is focused on the benefits towards humanity. Everything that benefits, that make humanity comfortable and convenient is part of the goal of Society 5.0 as compared with Society 4.0. So there should be, we are expecting in Society 5.0, we are expecting comfort, we are expecting vitality, and we are expecting high quality of lives regardless of social status. Okay? So as mentioned in the definition, it is human-centered, okay? Focused on solving social problems or social challenges by the use of the innovations developed during the fourth industrial revolution. Okay. So how could we come up with comfort? How could we come up with vitality and high quality of lives expected in Society 5.0? So we have here by providing goods and services that granularly address manifold latent needs without disparity. We also have advanced fusion of cyberspace and physical space. We have balancing of economic advancement with the resolution of social problems. So all these are ways in achieving Society 5.0 for us to have comfort, vitality, and high quality of lives as humanity. So that's it. That is another slide for the explanation on Society 5.0, on how are we going to achieve Society 5.0. Okay, so how does Society 5.0 work as compared to Society 4.0? So it is reflected in our slide. So what happened during Society 4.0? Okay, and what will be happening or what is now happening in Society 5.0? Okay, so on the left side of the slide is a presentation of what had happened during Society 4.0 or the information society, and what is supposed to happen or is happening now in Society 5.0 after 2015 pronouncement or proposal of the government of Japan. So let us take a look on the left side with regard to information society or society 4.0. You will notice that the gathering of information and sharing of information is somewhat limited. Although there is already that Internet of Things, there are already computers, there are already robots during Society 4.0, but the problem is it is limited to who uses those innovations of the fourth industrial revolutions. Whereas in Society 5.0, there is accumulation of this vast information, the so-called big data, and it will be analyzed by uh, artificial intelligence. So this big data is collected by Internet of Things and analyzed by artificial intelligence. Okay, so because there is already an artificial intelligence, it would be available to whoever uses it. So it is not anymore limited to a certain demographic like young generation, okay, or the middle-aged generation, or those who have money, or those who are in the average class in the society up to the rich, okay? Because of artificial intelligence, because of Internet of Things being used productively under Society 5.0, the benefits of these innovations of a fourth industrial revolution can be accessed or can be enjoyed by everyone in the society. Okay, so I am presenting here to you the difference or the comparison in narrative between Society 4.0 and Society 5.0. So again, in Society 4.0, there are already these technologies. But the problem is there is difficulty in sharing this knowledge and information across different demographics. Okay? Whereas in Society 5.0, everything can be enjoyed by every person regardless of status in life. Okay. The second one, access to a cloud service in cyberspace via internet, search, retrieve, and analyze data has been still being done by human. Whereas with regard to Society 5.0, high degree of convergence between cyberspace and physical space is present. Okay? So in Society 5.0, the technology is already proposing to humans best options. Okay? Whereas in Society 4.0, it's up to the human, the person, to analyze and to come up with decision. Okay, another difference between Society 4.0 and 5.0 is there is collection of information via the network and have it analyzed by humans, as I have discussed. Okay, but in 5.0, this big data from sensors, okay, is accumulated and analyzed by artificial intelligence, and the results are fed back to humans. So now, the only thing that humans will do is to choose which of the options is best for his course of action. Okay? So no need, or there is no requirement for human being to analyze data and come up with possible options and choose among the options the best course of action. And the last one, in Society 4.0, too much emphasis on economic growth and little on the well-being of the planet and people. So it is very much profit-centered, okay, in Society 4.0. Whereas in Society 5.0, there is a social contract that focuses on the planet, the people, and a meaningful economy that everyone enjoys. Okay, so those were the basic concepts about Society 5.0. Now, the next thing is how would Society 5.0 affect the law on contract? That's the reason that I am presenting to you the basics in law on contracts in our perspective, in Philippine perspective. So I will be presenting to you basic principles of contract in the Philippines, which I believe are comparable with your contracts law in Indonesia. Okay, so we have here the definition of contract in our civil code. Okay, so our contracts law is a portion of the Civil Code of the Philippines. So we have this law, Republic Act 386, okay, of June 18, 1949, called the Civil Code of the Philippines. And under Book 4 of our Civil Code of the Philippines are provisions on obligations and contracts. So particularly, Title 1 of Book 4 of our Civil Code of the Philippines is entitled Obligations, and it has a lot of provisions from Articles 1156 up to 1304. Whereas Title 2 is entitled Contracts, and it has provisions from Articles 1305 up to 1422. Okay, so our Civil Code of the Philippines is actually strongly influenced by Spanish Código Civil that was imposed in 1889, okay, when the Philippines is still under the Kingdom of Spain. So it is known to us that the Philippines has been under the Kingdom of Spain for more than 333 years, starting from March 17, 1521. And we were colonized for more than 300 years. So almost all of our laws are influenced by the laws of the Kingdom of Spain. So we have here, in our law on contracts, we have here the definition of contract. That is, a contract is a meeting of the minds between two persons whereby one binds himself with respect to the other to give something or to render some service. Okay. And in our law on contracts, we have 3 stages: negotiation stage, we have perfection stage, and we have consummation stage. When you say negotiation, this involves the preliminary negotiation and bargaining, discussion of terms and conditions with no arrival yet of a definite agreement. The parties provide their offers and bargain with each other. Okay? Next, we have perfection of contract. When the parties have already come to a definite agreement on a definite subject matter and valid cause, and all the essential elements are present, that is perfection. So there is already execution of the contract. But execution of the contract can be oral or can be in writing. Okay. So, and the third stage of contract law is we have consummation. In consummation, the terms of the contract have already been performed. So it is done already, or that the contract has been fulfilled, resulting in its accomplishment. Okay. We have here 5 fundamental characteristics of contract law in the Philippines. We have consensuality, based on consent. We also have autonomy. That is freedom or liberty to make contract. We also have mutuality. Okay? We have obligatory force. So this means that the terms and conditions of a contract is the law between the parties. That's why all parties to a contract must comply with the terms and conditions of the contract. The contract being the law between the parties. And we also have here relativity. Okay, meaning this only binds with parties or who are privy to the contract. Okay. So on consensuality, the perfection of contract is generally by the meeting of the minds or consensual, save for some cases where delivery or form is required for its perfection. So that's the general rule on consensuality. For as long as the parties manifested their consent to the contract, the first element of contract is already present. That is consensuality. So we also have here autonomy, okay, or the freedom or the liberty of the parties to enter into a contract for as long as the terms and conditions are not contrary to law, okay? We have morals, good customs, public order, or public policy. So anything that is contrary to law, morals, good customs, public order, or public policy is void, okay, or cannot be subject of a contract. So we have here another characteristic of contract in the Philippines. It's mutuality. The contract must bind both the contracting parties. Its validity or compliance cannot be left to the will of one of them. Okay. These are just general rules, class. Next, we have obligatory force. Obligations arising from contract have the force of law between the contracting parties and should be complied with in good faith. Otherwise, there would be penalty, or the other party, the so-called aggrieved party, will have a cause of action against the non-compliant party. Next, relativity, that says the contract takes effect or is binding only between the parties. Their assigns and heirs, which are referred to as privies. So that is relativity. So if you are not a party to a contract, you are not bound to follow or to comply with its terms and conditions. Okay. So those were the general principles or characteristics of Philippine contracts law. We have here elements of contracts, or what composes contracts in the Philippines. So we have here essential elements, we also have natural elements, and we also have accidental elements. And when you say essential elements of contract in the Philippines, those elements without which the contract cannot exist, or the basic ingredients of contract. They are necessary for validity of contract and may not be waived by the parties. Absence of any of the essential elements will make the contract void, and the remedy of the injured party is declaration of nullity. Okay. So it means that if there is lacking essential elements of contract, the contract is void from the very beginning. Okay, we also have the so-called natural elements, those which exist as part of the contract, even if the parties do not stipulate it, because the law deemed it written therein. So meaning, it is inherent. Natural elements of a contract are those elements that are inherent of a contract. So like warranty against eviction in contract of sale, or the warranty against head-in defect. So these two kinds of warranties, even if not present or even if not included in the contract, it is deemed included therein. Those are natural elements. Okay. We also have accidental elements of contract, those that do not normally exist in a contract unless stipulated. This is contrary to the natural element because if there is no stipulation or provision in the contract, that provision is considered as excluded in the contract. It is as if that the parties did not agree on that particular undertaking or particular endeavor. So like stipulation for interest, for the payment of interest. If there is loan of money and there is no stipulation that the debtor will pay interest, then the creditor cannot demand interest. Okay, so what are those essential elements? The absence of any of the essential elements would make the contract void from the very beginning. So we have here COC, we have consent, we have subject matter or object, and we have cause or consideration. Again, class, these three essential elements are general rules. Okay? Like for example, consideration. We say that cause or consideration is an essential element of contract, absence of which would make the contract void, right? But how about in case of donation? That the donee will not give anything to the donor, right? So again, because even in essential elements of contracts, these are the general rule only. Okay, so the first one, we have consent. Of course, if there is no consent, there is no contract because there is no meeting of the minds between the parties, between at least two parties. Okay, so we have here the meaning of consent, the meeting of the offer and the acceptance upon the thing and the costs which are to constitute the contract. Okay, we have your requisites of consent for us to say that there is a valid consent. So it must be intelligent, not subject of a mistake or fraud. Number two, we have it should be free or voluntary, not subject of undue influence, intimidation, or violence. And number three, it should be spontaneous. Number four, it should not be vitiated. Okay. So these are the requisites of consent. Otherwise, without these requisites, we cannot say that consent is present. How about object as an essential element of contract in the Philippines? Okay, object is to create or to end obligations, which in turn may involve things, rights, or services. The subject matter of the contract. So it must be within the commerce of man. That's the first element of or requisite of a valid subject matter. And it must be transmissible from the promisor to the promisee. Okay, number three, it must not be contrary to law, morals, good customs, public order, or public policy. Number four, not be impossible, like the debtor will promise to the creditor that next week he will give him the moon or the sun. The subject matter is impossible. Okay? So number five, we have it must be determinate or specific as to its kind or determinable without the need of a new contract or agreement. So those were the requisites for a valid subject matter. I hope that we have the same provisions in your civil law. And the third one, the third element, essential element of contract is the consideration. Okay, we have here the general rules on consideration. We have contracts without cause or with unlawful cause produce no effect whatsoever. Okay? The cause is unlawful, again, if it is contrary to law, morals, good customs, public order, or public policy. Okay. So supposing there is a sale, the seller and the buyer agreed that the seller would be selling his car. Okay? And the buyer will be paying the seller by giving the seller cocaine. That is contrary to law, right? So therefore, valid consideration is absent, making the contract void. Okay, so the statement of a false cause in contracts shall render them void. If it should not be proved that they were founded upon another cause which is true and lawful. Although the cause is not stated in the contract, it is presumed that it exists and is lawful unless the obligor proves the contrary. Okay. And inadequacy of the consideration will not affect the contract except when expressly provided by law, like the so-called lesion in our civil code, will the so-called lesion, meaning the consideration is insufficient for a certain percentage of the subject matter, or where there has been fraud, mistake, or undue influence. Okay. So formalities of contract in the Philippines. The general rule is, in the Philippines, a contract can be entered into verbally or in writing. So the general rule here in the Philippines, no form is required for the validity or perfection of a contract. That's the general rule. There are a lot of exceptions. Okay. So we have here formalities as requirement for validity in case of donation of real property requiring public document. Because in donation, in conveyance of real property in the Philippines, it will be registered in our registry of deeds under the Land Registration Authority. So there must be a document that you have to present to the registry of deeds for the registry of deeds to do the recording and the transfer of title to that real property. Okay? That's the reason that when it comes to donation of real property, it must be in public document, meaning it is notarized. Okay, number two, we have stipulations to pay interest on the use of money. Okay, it requires to be in writing because again, payment or stipulation for the payment of interest is only an accidental element. It is not an essential element. It is not a natural element, but it is an accidental element. Okay, the existence of which in the contract, okay, must be specified. If not specified, it means that there was no agreement as to payment of interest. Number three, we have contribution of real property in a partnership, which requires that there be inventory attached to a public instrument. So in the Philippines class, if you will be forming a partnership and there is contribution of real properties, like you will be contributing your land, okay, the articles of partnership must be in writing. Okay, and we have another example is your contract of marriage. Okay, it must have all the solemnities required by our family code. Okay, and it must of course be in writing because it will be registered in our civil registrar and goes to the Philippine Statistics Authority. So those were some of the examples of contracts or documents that should be put in writing whether private document or public document to be valid as an exception to the general rule that contract may be in writing or oral. So another exception to the general rule that contract may be entered into in writing or orally is when it is required for enforceability. So meaning the agreement is valid but cannot be enforced, or it is difficult to enforce a document when it is not in writing. Not necessarily that it is invalid. Okay? But the problem is the possibility of implementing the agreement or the document because it is not denominated in writing. So we have here formalities as requirement for enforceability. Okay, we have here the following at least 3 examples. An agreement not to be performed within 1 year from execution. So if you and I will enter into agreement whereby I will be rendering service to you in 2026, that should be put in writing. Otherwise, come 2026, you cannot compel me or demand that I perform the services that I have promised now. Okay? That is within 1 year from execution. Okay, the second example is a special promise to answer for debt or marriage of another. So in the Philippines, if you will be, or miscarriage of another. So in the Philippines, if you are promising to shoulder the debt of another person from the creditor, it should be put in writing. Okay, number 3, we have a lease for more than 1 year. So the renting of property. If the lease period is more than 1 year, it should be put in writing. Okay? Or for the sale of real property or of an interest in a real property. Again, the problem with regard to the conveyance of real property, if not put in writing, aside from it would not be valid, is how are we going to enforce that? How are we going to ask the government, like the Registry of Deeds in the Philippines, to record the sale and eventually to transfer the title on the real property? Okay. So another scenario where formalities are required, and that is for convenience. So we have here 2 examples, acts and contracts, which have for their object the creation, transmission, modification, or extinguishment of real rights over immovable properties. For as long as the subject matter in the Philippines is immovable, okay, for convenience purposes, it should be made in writing. Okay. The power to administer property or any other property which has for its object to bind third persons. Especially, we can execute here a special power of attorney. Okay, that is one example of item number 2, the power to administer property or any other power which has for its object to bind third parties. Okay, now, having known the basics of contract law in the Philippines vis-a-vis our basic knowledge on Society 5.0, the question now is, what are the challenges and opportunities in regard to contracts law under Society 5.0? Going back to my question in the introductory, are we supposed to fear the coming or the happening of Society 5.0? And by the way, class, Society 5.0, although this has started sometime in 2015, and there are some authors who are saying that there is just a gradual um, happening or effect of the Society 5.0, but 9 years after, and that is now, there are a lot of manifestations that Society 5.0 is already happening in our society. One of which is the way you transact uh, banking matters, right? In the Philippines, I think also you might be more advanced than us, but in the Philippines, we can do banking transactions already in our cell phones. So the withdrawal, the transfer or the deposit of money, the transfer of money from one bank account to another bank account can be done using cell phones. So no need for you to physically go to the bank and transact with bank teller, or go to the bank and withdraw cash and deliver the cash as payment for debt owed. Okay? So even the existence in the Philippines, even the existence of Chat GPT, the so-called Chat GPT, is a manifestation of the existence or that Society 5.0 is already happening. Okay. And also, we have here a very known food chain that some of its outlets are having robots to assist the customers. So those are manifestations that Society 5.0 is already happening, or we are already in Society 5.0. Okay, so we have here, I listed here at least 4 or 5 factors or things that we should know to determine what are the challenges and opportunities in 5.0 as regard to contract law. Okay? So as regard to contract law, what are the challenges and opportunities that we, lawyers or disciples of law, will be or are encountering? So we have heard the first factor. Even within one country, not everyone will move towards Society 5.0 at the same speed. Why? Because of diverse demographics in a particular country. Like in the Philippines, okay? Reflected on the right side of the slide is the diversity, are the factors that make the Philippines diverse. So that includes ethnic groups, that includes income groups, and even gender, we have it, even religion, and even the scattered locations. We have a lot of islands. We have thousands of islands in the Philippines, just like you. Okay? So those were some of the factors that determine that the existence of Society 5.0 may not happen simultaneously within a particular country. Okay? Like it could be that Society 5.0 is very obvious in the urban areas, but not in the rural areas. Okay? It could also be that Society 5.0 is being enjoyed more by young generations. Okay? So it depends upon the diverse factors in a particular country. Okay. Number 2. And also, when it comes to, with regard to how would lawyers take into consideration the diversity of a country in relation to his practice of profession. Okay? So if you were a lawyer in rural areas, we can expect that you have least benefit from Society 5.0. But if you are a lawyer practicing in urban areas like in Metro Manila, okay, we can expect from you that you are being benefited by Society 5.0 already, or you are experiencing Society 5.0 already. That's it. So even in contracts preparation of a lawyer, so if you were a lawyer in Metro Manila or in the urban area, you can make use already of the benefit of Society 5.0, right? Because by using ChatGPT, you can draft your contract. Whereas if you are practicing in rural areas, in far-flung provinces, you are not expected to be benefited by the fruits of Society 5.0. You might even be settling with browsing your books in the preparation of contracts. Okay, so another matter that we have to determine with regard to challenges and opportunities in contract law in Society 5.0 is the fact that contracts are protected by existing laws of the country. So whether it is in the Philippines or in Indonesia, okay, contract law is included in a particular law. Like in the Philippines, we have the so-called Civil Code of the Philippines. So the preparation of contract from negotiation to perfection and to consummation are governed by the provisions of the Civil Code of the Philippines. Okay, so what does it mean with regard to the application or the existence of Society 5.0? Okay, so how does each other has effect on one another? Okay, so because contracts law in the Philippines is governed by the Civil Code of the Philippines, so even if there is already an existence of 5.0, Society 5.0, or even if Society 5.0 is already happening in the Philippines, yet because contracts are protected by our laws, therefore, we still enjoy preparing contracts based on the provisions of the Civil Code of the Philippines. Okay? Only that in the preparation of contracts, there is already an instrument that will make contract preparation efficient. Okay? So we have that ChatGPT and all other innovations under the fourth industrial revolution. So you could see that between challenges and opportunities, actually the existence of Society 5.0 is more of an opportunity on the part of lawyers, particularly in the preparation of contracts. So there is no contradictory effect or contradicting effect between the existence of Society 5.0 and contracts law on one hand. Okay? Next, we have another factor is the involvement of lawyers and notaries cannot be replaced even with the existence of Society 5.0, even with the existence of robots, okay, or artificial intelligence. We also have Internet of Things. because we are simply sui generis lawyers. So involvement of lawyers and notaries cannot be replaced. Especially, of course, that the existence of lawyers and notaries in the Philippines is also protected by law. And of course, to talk lightly about it, almost all members of our Congress, whether in the Senate or in the House of Representatives, are composed of lawyers. So of course, they will not permit that uh, negative effect of Society 5.0 will happen to lawyers or to those who are practicing law in the Philippines. So we are indeed irreplaceable, despite existence of the innovations of the fourth industrial revolution that shaped up Society 5.0. Next, we have artificial intelligence as a major mover or element of Society 5.0 is actually an instrument for efficiency in contracts preparation. Okay? So that's it. So for as long as you are open-minded, regardless of your age as a lawyer, whether you are a young lawyer or you are on advanced age, for as long as you are open-minded, okay, you can make use of Society 5.0, especially artificial intelligence for your efficiency in your legal practice, more particularly in contracts preparation. Okay. And the last one, we have openness of lawyers to embrace change and make better use of these changes or better use of Society 5.0 in the profession, in the practice of their profession. So as I have told you, it all depends on us lawyers. Okay? So no need for us to fear the future because the future is already happening. Okay? What we need to do is to be open-minded and take advantage on these technologies in the practice of our profession. Okay? So that would be all. And I have here listed my references in coming up with my lecture. So we have the Cabinet Office Government of Japan website. I have given you also the link. We have the report on the 5th Science and Technology Basic Plan, Council for Science, Technology, and Innovation of the Cabinet Office, Government of Japan. Okay. We also have here Society 5.0, a new social contract by Miguel Cody, University of Governance, and also I made use of the Civil Code of the Philippines. So that would be all, class. Thank you for listening.
Thank you, Mr. Judo. I think it is interesting for us to learn how the Philippines develop their civil code. Yeah. I think it is also interesting while you make a connection between between the civil code in the Philippines and what's that and the movement of the Society 5.0. Okay. Everyone. Now we are going to have a question and answer session. So, those willing to raise a question, please click the raise hand Google on your Zoom screen, please. Okay, Ibu Detania, your turn. Operator, could you have Bu Detania to unmute herself?
Am I the one to unmute? Okay.
No. Okay, Bu Detania,
Yes.
please.
Thank you for the opportunity, and thank you, sir, Professor, for the presentation. I would like to ask a question on your
Sorry, Bu
explanation.
Detania, can you make your
Your
voice?
voice come in choppy.
Okay. What about now? Is it better?
Yeah, it's better.
Okay.
Okay.
Sorry, because it's a bit noisy from where I am. So I would like to ask a question on your explanation on the requirement on the validity of contract under the Philippine law when you address both uh, cause and consideration uh, uh, in the same, simultaneously. So my question would be, is under the Philippines law, the concept of cause and consideration are treated as the same, or
Yes.
both treated differently with, but also resort to the validity of contract, because as a comparison under the general laws of contract in Indonesia, we don't it does not explicitly require consideration for the validity of the contract unless it is specified in a specific law for specific contracts or transactions, for example. So it kind of implies that in general, contracts in Indonesia does not necessarily have to be reciprocal. Can you probably explain more on this? Because I understand that the Philippines also has applies the civil law system like we do, but up until today, we have not modernized our general laws on contract as in our civil code. Thank you. So that will be my question.
Well, thank you for the question. In the Philippines, under our Civil Code of the Philippines, the cause is the same with the consideration. That's the reason that under essential elements of contract, there are only three essential elements of contract. We have the consent, number one. We have the object or subject matter. And the third one is the cause or consideration. Okay? So the cause is can be alternately called consideration or the other way around. So it is not a separate element. The cause is not a separate element from consideration. I do not know in your jurisdiction if the cause and the consideration are two different things. Are they two different things?
Yeah, yes, you can, but I think the operator, can you help Bu Detania to unmute herself? Operator, Bu Detania?
I actually think it's inconclusive, Professor. If we look into a few literatures in the comparison between civil law contracts and common law contracts, there are literatures that explain that both have differences conceptual wise. The concept of legal cause and the Indonesian general contract only relate on
I cannot hear you, madam.
yeah, okay. What about now? Sorry, Professor. Is it okay now? Hello?
Your voice is fluctuating. May I use my
Bu Deta, would you please remove your earplug, I think, and then you can use your what's that built-in microphone and
Okay,
speaker, right?
okay. Let me
It's much more clear.
Yes, that's clear.
better now?
Yes.
Yeah,
Okay,
perfectly
sorry
clear.
about that. So under the general laws on contract in Indonesia, the concept of legal cause only explicitly referred to for contracts not to violate the law, statutory regulations, morality, and public order.
So it does not go into details on the concept of consideration. So if we try to look further into literatures, well, at least the literatures that I've been digging in, some would suggest that the concept of legal costs and consideration are two separate and different conceptual concepts. So that is why I find it interesting that under the Philippine law that it treats both as the same elements. So yeah.
Yes, thank you. So even with that, we can already see the comparison and difference between our two laws, right?
Yeah. Yes. Thank you. So it's new information for me. Thank you very much.
Thank you, Madam.
It seems like what's that? An interesting point, yeah, to have a comparative approach here, I think, between the Philippines and the Indonesian civil code. Okay, thank you, Bu Detania and Mr. Jodo. The next participants, another question. Is there anyone else would like to raise a question here?
You have to ask questions. Otherwise, I will give you a quiz. There will be a 10-item quiz.
Oh yeah?
Yes. I
Is there
sent
any
it via Yes. I sent it via through Professor Ulep.
Hmm?
Yes. 10 item quiz.
Yeah, but the quiz, I think it will be conducted by the participants after the session, I think.
Oh, that's good.
And it will be
Anyway,
announced by the Master of Ceremony, I think. Okay.
yes. Anyway, the slides will be distributed to the students, right? To the participants.
I think while we are waiting for the next question, I would like to ask you about it is interesting, yeah. It is interesting to have what's that, a fact, that Indonesia and the Philippines has a historical context, the same historical context, yeah. Being what's that, colonized countries, yeah, in the past. I would like to know how did the colonized the colonial government set the rules for the Philippines. I would like to know the historical perspective there.
Well, the codification of in particular the civil laws of the Philippines have been codified only lately. And even upon the start of the Spanish colonization in the Philippines in 1521, there is no introduction formally of Spanish laws in the Philippines. So it was only codified only lately, and then all other laws were just separately made by the colonizers, but there was no code at that time.
Okay, so it is what's that? It was late, yeah, to establish the civil. I'm sorry, code of civil, yeah, Mr. Judo.
Yes. Well, with regard to the Spanish Civil Code, it was introduced to the Philippines only after almost 300 years of governing us in 1889.
Okay, it's
So
clear now, I think.
prior to 1889, there was no
No.
account. There was no account that there was already the Spanish Civil Code being in effect in the Philippines.
Yeah, I think it was. I'm sorry. It happened after the French Revolution, I think. Yeah.
Yes, yes.
Okay, thank you so much, Mr. Judo. Anyone else would you like to raise your hand and deliver your question? Okay, no one, I think. Okay, once again, I would like to thank you to the our speaker, yeah, Mr. Judo, for coming to this session. And then I think it will be it is our ends, yeah, to conduct our fifth session here. We still have 1 day left to complete the short course, so keep your spirit there, guys. Okay, so I think I would like to give back this chair to our good looking masters of ceremony, I think. Thank you so much.
All right. Thank you so much, Mr. Albordo, for sharing yet another insightful knowledge within your area of expertise in our second discussion session. And last but not least, another massive thank you to Mr. Kuku Prasetyo for always leading it.
All right. In order to fulfill our final agenda, we would like to encourage all of the participants to turn on their camera for our second and final photo/documentation session.
All right, for the first slide, make sure you all are ready to show us your bright, beautiful smile. Second slide. 3, 2, 1, cheese.
Okay, next slide. All right. Next slide, please. Okay.
All right. And with that, our fourth day of Yarsi International Short Course 2024 has come to an end. To close out our valuable day, let's recite Hamdalah together.
Alhamdulillahirabbil alamin. On behalf of our entire team on duty for today, we would like to sincerely apologize if there are any mistakes or inconveniences in the making and execution of this event.
I am Aldafi Irfan Abrar and my partner,
Muhammad Dafa Bayanaka,
as your masters of ceremony on day 4 of Yarsi International Short Course 2024, would like to say a huge thank you for your precious time and kind attention. Wabillahi taufiq wal hidayah. Wassalamualaikum warahmatullahi wabarakatuh.
Waalaikumsalam warahmatullahi wabarakatuh. Thank you.